there, my name is Anushka and I'm a first year law student at Taylor's University. My groupmates and I were given the opportunity to broaden our understanding of statutory interpretation as part of our English legal system assignment. The Parliament of the United Kingdom is the sovereign lawmaker in the land. It possesses legislative supremacy and thusly paramount power over all political bodies in the UK. The Parliament can pass any legislation they see fit. These Acts of Parliament, also known as statutes, are the highest form of law in the UK. There are so many needs for statutes, making them such an important part of the legal system. To name a few, statutes are needed to regulate new areas of law, repeal laws that are no longer needed or are relevant, or to even consolidate earlier sources of law. Statutes are also needed to implement the UK's international obligations, such as the Human Rights Act of 1998. The ambiguities in these statutes tend to give rise to the need of statutory interpretation. Sometimes words are omitted, too ambiguous, or there might have even been an error in drafting that escaped unnoticed. Statutory interpretation is also needed to tackle new developments in law and society. For example, changes in social trends, technological advancements, or even new situations that are newly raised that were unforeseeable at the time the statute was passed. Once Parliament passes an act, they do not release a separate document stating their mundane intention or correcting these errors. What it is intended to be is to be interpreted from the wording of the statute itself. Being that it is the purpose of the judiciary to interpret legislation, judges have established legal rules for interpreting statutes in the cases tried before them, as well as a variety of other secondary aids to interpretation. The Supreme Court held in the case of Cusack and London Bureau of Herald that these approaches are to be treated as guidelines and not rigid rules. Lord Tyndall defined the literal approach as the worlds themselves alone do, best declare the intention of the lawgiver. It's arguably the most important rule of statutory interpretation in the legal system. It gives all words in the statute their natural and literal meaning, even if the outcome is somewhat irrational. For example, in the case of Fisher and Bell, the court interpreted the Restriction of Offensive Weapons Act 1959 as a statutory prohibition of selling or offering for sale any flake knife as including only offers for sale and not an invitation to treat, as interpreted under contract law. Consequently, the defendant was acquitted regardless of the fact that he was engaging in the very activity that the prohibition statute was intended to prevent. The literal rule ensures that any layperson is able to know in advance the legal consequence as it would be interpreted exactly how it is written. This makes the law more certain and it is easy to apply. The literal rule also guarantees that the doctrine of separation of powers is held. Lord Diplock in the Dupont Steels Limited and Sons claimed that the British Constitution is firmly based upon the separation of powers. Parliament makes the laws, the judiciary interprets them. However, every rose has its thorns. Similarly, there are disadvantages to using the literal rule, the most prominent being that it creates absurd and unjust outcomes. Related to that, we can also be said that it disrespects the will of Parliament, as they probably did not intend for absurd or unjust results. If the literal rule produces an absurd and irrational result, then and only then the judge will step in by giving the statutory provision a more rational meaning in light of the statute as a whole. The golden rule can be described in two different ways. In the narrow approach, where a particular word in a statute has several possible meanings, the court can choose the one which avoids absurdity and avoid the others. A common case example is Adler and George. The second being a wide approach. This is when the court can decide that the overall outcome of reading the statute literally would be absurd and interpret it differently, to avoid the absurd outcome as applied in the case of Ray Segworth. An advantage to this is that it helps the courts to put into practice what Parliament probably intended by avoiding absurdity and injustice, which would result because of the literal rule. The downside to this is that there is no single definition of what amounts to absurd or unjust. What may be irrational to one judge may not be so to another, leading to unpredictability in the deciding of cases.
Hello, my name is Akshay, and I'll be talking about the mischief rule and the purposive approach. Now, the mischief rule originated from the Hayden's case in 1584, where there was a conflict over legal action against Hayden for trespassing on certain land. This technique focuses on how to interpret the statute in a way that solves the mischief that Parliament was trying to address in the statute. Three factors that judges should consider when applying the mischief rule is that what was the law before the statute passed, what was the mischief that Parliament was trying to address, and what was the remedy that Parliament was trying to provide. In the case of Elliot vs. Gray in 1960, Elliot left his broken down motor car in the road outside of his house and was convicted under the Road Traffic Act in 1930, Section 35, Subsection 1, which had stated that it was an offence for having an uninsured car used on the road. Even though the car was jacked up and its battery even removed, upon applying the three factors, the court held that it was nonetheless a hazard for the car being on the road, stating that even though it can't be driven, the car can still be moved. As such, the owner had the use of the car on the road, which upon that section was guilty of an offence. This was the mischief that Parliament was trying to address, that there is an existence of a hazard on the road. The mischief rule has its advantages. One of it is that it avoids absurdity and injustice. As such, it works in a broader aspect to help prevent what Parliament had intended, and it fulfills the intention of Parliament when the statute was enacted. Another benefit is that it promotes flexibility. The Law Commission report in 1969 had even described that the mischief rule was a rather more satisfactory approach compared to the other two rules. However, there are some disadvantages that follow the mischief rule. One of it is that it gives more power to the judges to adjust the word of the statute to fit their desired outcomes. And as well, in reference to the Hayden's case, statute law only played a minor role compared to the common law at that period of time. As such, it was easier to ascertain what was the statute's purpose. However, nowadays, it is far more difficult as the purpose of legislation is not very straightforward. Now, the purposive approach, the rule is broad, as it gives judges the effect to think, what is the purpose of the legislation? And judges are not constrained to find out the meaning of the phrase that was used by Parliament to solve the problem. As such, courts can look at the whole context when interpreting statutes. It can be said that a more liberal approach has been taken compared to the mischief rule. Over time, courts have acknowledged that using purposive approach when interpreting statutes. This is more likely due to influence of interpreting EU legislation, which focuses on giving effect to the purpose of the legislation. Another reason is that due to the statute's increasing volume. After the case of Pepper v. Hart, courts are now willing to adopt a purposive approach to give effect to the true purpose of the legislation. In the case of R. Mr. Secretary of State for Health in 2003, a new form of human reproduction was discovered. The Labour government at that time issued a statement that this medical research was fit within the Human Fertilization and Embryology Act 1990, but the pressure group pro-life was against this research. The House of Lords interpreted this act using the purposive approach to show the true intention of Parliament and concluded that Parliament at that time could not have intended to include this new form of medical research from being regulated in the Act. The advantages of the purposive approach is that it provides maximum flexibility on how to interpret statutes in new and or unforeseen circumstances. Courts can even update statutes to tackle new technological and social developments faster than Parliament. However, the disadvantage about it is that courts may end up distorting the meaning of the statutes to fit their purpose. And by the growth of purposive interpretation, tremendous power has been given to unelected judges. This means the courts are getting more power and they are the ones who are getting the last word instead of Parliament. This, as such, can disturb the people's notion of Parliament sovereignty.
Hi there, I'm Azita and I shall explain the 3 rules of language that courts have resorted to when reading an act. In looking at the other words in the act, the courts have developed a number of minor rules that can help to make the meaning of words and phrases clear where a particular sentence construction has been used. To start with, in Latin there is ex generis. In this rule, general words which follow specific ones are taken to include only things of the same kind. This means that the general statement is assumed to refer to items that belong to the same group as the ones mentioned specifically above. in terms of either qualities or characteristics. In Allen and Emerson, the court took theatres and other places of amusement to also apply to a fanfare. This is despite the fact that fanfare and cinemas do not really fall under the same category. Secondly, expressio unias est exclusion alterias. This is where there is a list of words which is not followed by general words. Then the Act applies only to the items on the list. This therefore means that for as long as the item being considered is not specifically mentioned in a statement not followed by general words, then it is not included in the Act. A perfect example was in Tempest and Kilner, where the court took note that the list goods, wares, and merchandise was not followed by a general phrase, and so did not include shares and stocks. As a result, the Statute of Frauds 1677 did not apply to the latter, but only those clearly stipulated. Lastly, nocita a sociis. This means the words must be looked at in a context and interpreted accordingly. It involves looking at other words in the same section or at other sections in the Act. In Inland Revenue, the court decided that interest meant annual interest because of the section that mentioned interest, annuities, or other annual interest. As a result, more parts of the Act will be looked to determine the meaning of a term.
Good day, Dr. Wilson. I'm Gayatri Govindasamy, and I'll be sharing with you on the aids to interpretation. Aids to interpretation is a wide range of material that may be considered by a judge when interpreting statutes. Some of these aids may be found within the statute in questions, and others are external to the statute. They are also known as the intrinsic aids and extrinsic aids. Intrinsic aids are sources within the Act, which can also be called as internal aids. In order to determine the meaning of a section of an Act of Parliament, the judge may wish to look at other sections in the Act. Usually, literal rule and golden rule both direct the judge to internal aids. The intrinsic aids include of title. This title can be segregated into short title and long title. The short title of the Act is purely for reference only. The short title is merely for convenience. For example, this Act may be cited as the Interpretation Act 1978. As for the long title, the heading of the statute is the long title and the general purpose is described in it. For example, under the Interpretation Act 1978, the long title reads as follows: An Act to consolidate the Interpretation Act 1889 and certain other enactments relating to the construction and operations of Parliament and other instruments, with amendments to give effect to recommendations of the Law Commission and the Scottish Law Commission. Also, schedules form a part of the statute. They are at the end and contain minute details for working out the provision of the express enactment. The expression in the schedule cannot override the provisions of express enactment. Preamble is also an intrinsic aid. The Act starts with a preamble and is generally small. The main objective and purpose of the Act is found in the preamble of the statute. In a nutshell, it is a preparatory statement. There are always headings to support any ambiguities in the word of statute. A group of sections are given under the heading, and they are also treated as preambles. There are also guides given under the interpretation clause, where judges are able to retrieve any sort of definition related to the words of the Act. As the saying goes, when the Act itself provides a dictionary for the words used, the court must first look into the dictionary for interpretation. In addition, punctuation is disregarded in the construction of statute. Punctuation cannot control, vary, or modify the plain and simple meaning of the language of statute. On the other hand, we have the extrinsic aids, which are aids provided beyond the Act. It is widely used in the case of mischief rule and purposive approach. Dictionaries, textbooks, or journals can be identified as an extrinsic aid. Judges may consult these materials to find the meaning of a word or to gather information about the views of legal academics. Aside from that, reports can also be referred to provide a decision in the case of Black Clawson International Limited and Paperwork Waldhof Eschenberg. Sorry if I pronounced it wrong. It mentions that official reports may be considered as evidence of pre-existing state of the law and the mischief that the legislation was intended to deal with it. Treaties and international conventions can be considered when following the presumption, and this will be further explained by Shireen. Apart from that, a judge may consider the historical setting of the provision that is being interpreted, as well as other statutes dealing with the same subject.
Hi, my name is Kevin Syke, and I will further explain more about Hansard and the use as well as the history of it. Firstly, Hansard is the official report of all parliamentary debates. 5 members, their contributions, debates, petitions, and divisions from public Hansard reports dating back over 200 years. Interestingly, the debates from Hansard are published on the website the next working day and can be accessed publicly. Hansard is adopted for statutory interpretation, mainly to look at the ministerial intention when they propose the legislation only when the meaning of the statute is unclear and uncertain. Until 1992, there was a strict rule that courts are not permitted to look at what was said in the debates of Parliament to find the true intention behind the statute when it is ambiguous. And prior to 1992, Lord Denning had tried to attack the ban of the use of Hansard to find the true meaning and intention of Parliament in the case of Davis and Johnson. The case involved of interpretation of Domestic Violence and Matrimonial Proceedings Act 1976, which Lord Denning admitted that he had indeed read the Hansard before making his decision, saying some may say, and indeed have said, that judges should not pay any attention to what is said in Parliament. They should grope about it in the dark for the meaning of an act without switching on the light, and he do not accede to this view. The case was in the Court of Appeal and was appealed to the House of Lords. Moving on to the House of Lords, Lord Sharmond then disapproved of Lord Denning's view by saying that such material is unreliable guide to the true meaning and it only promotes confusion but not clarity. However, the strict rule was abandoned in the case of Pepper and Hart. The House of Lords relaxed the rule and accepted Hansard for the first time to be used in a limited way. This case was rather unusual as 7 judges heard the appeal rather than the typical 5 judges, and only 2 disagree with the use of Hansard. One of the arguments against the looking at the Hansard was it will infringe Section 1, Article 9 of the Bill of Rights, 1688. Majority of the law lords rejected the argument. The majority ruled that Hansard could be consulted. But however, this does not mean Hansard can be generally adopted for statutory interpretation. The majority of the law lords put a limitation to it. Therefore, Hansard may be reconsidered after the Pepper case, but provided only when the words of the Act are ambiguous or obscure or lead to an absurdity. Even then, Hansard should only be used if there was a clear statement by minister introducing the legislation which will resolve absurdity and ambiguity. And this can be seen in the case of DPP against Wool, where limitation was taken into action. The court said that it had not looked at the debate because the legislation was ambiguous or absurd. And moving on to the wider use of Hansard, where it is permitted only where the court is considering an act that introduced an international convention into the English law. This can be seen in the case of Three River District Council against Bank of England. In this case, it is important to analyze and interpret the statute purposely and consistently with any European material, and the court can look at Hansard even if the statute is not considered to be ambiguous. Ever since, Hansard had been referred to a number of cases such as R against JTB and Wilson against First County Trust No. 2.
Greetings, Dr. Wilson. I am Shireen Nisha, and I shall explain about the law reform. The courts used to hold that reports by law reform bodies should not be considered by the courts. However, this rule was relaxed in the Black Clawson International Private Limited Company against Piperlink AG 1975, when it was accepted that such a report should be looked at to discover the mischief or gap in the law which the legislation based on the report was designed to deal with. An example of a case in which the court looked at a report is the DPP against Bull. Here the court considered the Wolfenden report of Committee on Homosexual Offences and Prostitution. This made it clear that the mischief which had been identified was that of women loitering or soliciting for the purposes of prostitution. The report did not identify any problem caused by male prostitution. Accordingly, the court held that Section 1, Sub 1 of the Street Offences Act 1959 applied only to women prostitutes. In Black Clawson 1975, the 5 judges in the House of Lords used the report to find the intention of Parliament. This is shown by Lord Brown Wilkinson in Pepper against Hart 1993. There have been cases since then in which the courts have not consulted the relevant report. For example, in Eddington against Ryan 1985, the House of Lords did not consult the Law of Commissions report, Criminal Law Attempt and Impossibility in relation to attempt conspiracy and incitement, Law Commission number 102, 1980. It was severely criticized. The Lords themselves accepted that they had made a bad error and they corrected it in the following year in R against Shivpuri 1986 when they overruled Anderton against Ryan 1985. Another case in which the relevant report was not considered by the House of Lords was Metropolitan Police Commissioner against Caldwell 1981. In the case, the House of Lords did not look at the report by the Law Commission, Report on Offences of Damage to Property Law Commission number 29, 1970, which led to the passing of the Criminal Damage Act 1971. In this report, the Law Commission had pointed out the old-fashioned use of the word malicious on the old acts where the word was meant to mean that the defendant either intended to do the damage or knew that he was taking a risk that it would be damaged. The Commission proposed that it should be replaced by the phrase intending or being reckless. This was the wording used in both the draft bill and the final act. It was clear that the Law of Commission meant reckless to cover situations where the defendant had realized that there was a risk but had gone on to take that risk. This is shown as subjective recklessness. However, in Caldwell 1981, when the word reckless. In Criminal Damage Act 1971 was considered by the House of Lords. It ruled that it covered not only subjective risk-taking but also situations where a reasonable person would have realized the risk but the defendant had not any thought to the possibility of there being any risk. This is also called the objective test. This decision was criticized, but it remained in force for over 20 years until Caldwell in 1981, holding that in that case the law lords had adopted an interpretation of Section 1 of the 1971 Act, which was beyond the range of feasible meanings. In R against G 2003, the Lords emphasized the meaning that the Law Commission had intended and which Parliament intended. Next, we have international conventions. We have already seen that where a national law is passed to give effect to the European Union Treaty or other law, the courts will look at the original EU law when deciding on interpretation. This is also the position where a national law has been passed in order to give effect to any international treaty or convention. In Salmon against Commissioners of Customs and Excise 1967, the Court of Appeal looked at an international convention because it thought that the English law should be interpreted in such a way as to be consistent with international law. In Fourth Guild against Monarch Airlines Private Limited Company 1980, the House of Lords decided that the original convention should be considered as it was possible that in translating and be adapting the convention to a legislative process, the true meaning of the original might have been lost.
I will now close by explicitly giving our final stand as a group on the matter of statutory interpretation methods. This conclusion was reached while putting two main qualities stated by Gary and Slepper in the question into consideration. That interpretation of legislative provision is a creative process, and two, that judges' contribution to determining meaning and effect given by law. After weighing the pros and cons, we found that it is the mischief rule that appears the most practical and favorable choice of statutory interpretation. According to Gary and Slepper, there has been a general shift from the literal approach towards the purposive approach in recent years. This suggests that it has become more acceptable to give increasing freedom to judges to use their creativity in the interpretation of law. Purposive approach has found favor with judges such as Lord Denning and the Maga and St. Mellons and Newsport Court case in 1950. However, it has been received with criticisms from the House of Lords, with Lord Siemens describing it as a naked usurpation of the legislative function in disguise of interpretation. With such controversy, the purposive approach may be a bit too extreme and not a good choice, as it also questions the idea of separation of powers as time goes on with judges' duties overlapping. As such, the milder and more assertive mischief rule is recommended, with its strengths already mentioned before. Of course, it is not free of criticism too, especially as it was first applied in the socio-political case of Hayden. However, it appears most suitable in reconciling the actions and intentions of Parliament with practicality, especially in changing times. Despite some questionable cases such as Cockery and Carpenter, this method has yielded more progress for the judicial system. Among some of its victories are Smith and Hughes, as well as the Royal College Nursing and DHS case. This approach is also appealing in that it is methodological in the use of the 4 questions mentioned earlier that are used to reach a conclusion each time. With that said, we come to the end of our presentation. Thank you for watching.